matter PB 14-24, Jermey Deere. This is a remand. Are you representing the city?
Yes, Samantha Holtz on behalf of the city and the Albuquerque Police Department.
And Thomas Rowe on behalf of Jermey Deere.
Again, this is a remand back to a personnel board, which has changed composition since we made that decision, so it's been an interesting position for us. In fact, the chair who actually wrote the decision on behalf of the rest of us has since retired. And we do not have a chair. I am the acting chair. I'll make that, or the vice chair, excuse me, not the acting chair, the vice chair. So I just want to make it clear for the record. What is your pleasure? What would you like to have them do? I mean, I don't know that they can summarize what the judge has asked us to do, the remand. They can respond to it unless you want them to do something else.
I've got a question or two.
I mean, we've got a 3-2 decision originally, so please go ahead.
My question that I'd like both council to address is, as the chairman just pointed out, we have a different board, and it's a 4-member board. And given that in this case the decision that was appealed from was a 3-2 decision, I'd like to hear from council on what you feel would be the effect of a deadlocked vote today if this board were to vote 2-2. What would be the effect of that, the legal effect of that? And I'd just like council's position on that issue.
Would you like the city to go first?
Sure.
Well, I think that when you have a remand from a court, a change in a decision from a court, especially when you have further direction from a district court, is not impossible and is not unusual. When a court says, look at this particular issue or reconsider this, it's not unlikely that a board would come back with a different decision. As far as coming back with a 2-2 deadlock decision, the merit system ordinance is pretty clear that if there is a tie amongst the board members, then it is deferred to the hearing officer's decision, and that stands.
Mr. Grover?
Well, I think, Chairman Reeves, your introductory remarks are extremely important, which is the landscape of this matter has changed since the decision was made by the board, which was we had 5 members, we're now down to 4, and we had different members than what we did now. Adding into that landscape, we also have pretty bewildering statements by the city's CAO excoriating the board for a decision that was made that he viewed as being disfavorable. So the tone and atmosphere has definitely changed since that decision was made so many months ago. That being said, I mean, the order issued by Judge Campbell doesn't call for a revote. It calls for the board to clarify the legal and factual basis of that decision. And that decision, again, was made by 5 individuals, not 4, and by individuals that aren't here anymore. And I'm not sure on what the remedy for those changes are, other than on its face you have to respond to what the judge asked for, which is to clarify the legal and factual basis of that decision as best as you can. It doesn't call for a revote, and we oppose a revote. The decision put forward as written by then Chairman Pfeiffer, fairly detailed and thorough in terms of what the decision by the board was based upon, which was, essentially the absence of this order that Mr. Deere was subjected to. And in some ways, Judge Campbell is asking for the board to provide further documentation of the absence of that order. I mean, how do you prove something that doesn't exist? And I guess it's up to you guys to figure out whatever in the record does it support that there is that absence of the order. Now, we don't want a rehearing on this. Things have come to light since the initial merits hearing that have definitely cast a ominous specter upon the actions and credibility of Chief Eden and his testimony in that hearing. And if we want to open up that can of worms, I think we're going down into a place that is incredibly complicated for the city. But that all comes back to Judge Campbell's remand to the board to clarify certain things in its decision. Not to have a revote, not to redo, but to detail the decisions or the basis for its decisions that was made back then on November 12th. Yeah, go ahead.
May I respond?
Just a second. Any response?
Okay. I just wanted to talk a little bit about, you made some comments about your remark, and I had not addressed those in the board's composition. Boards change composition quite frequently, and they still have to function, and it doesn't take away their power to move forward with the decision. And while the court is asking this board to clarify its decision, if the board as it exists cannot clarify or cannot come to a consensus as to what is a reasonable way to clarify, I think you do come to a deadlock, and that is something that you would then have to send back up to the judge, that is what has happened. If that makes, do you have questions about that?
Well, I didn't want you to assume we would come to a deadlock.
Okay.
We might not, we
Yeah,
might,
and that was
there are three of us who
question,
were
yes.
here for that decision, but I don't know that we would deadlock necessarily. I have to say I'm a little bit concerned about the city's statement of the appellate issues. Statement of the issues, number one, whether certain members of the personnel board were biased so as to deprive the city of Albuquerque of a fair review of the hearing officer's recommendations. I'm not quite sure what that means.
Well, I believe that there were statements made by members of the board, which the city felt led us to believe that there may be some unfair considerations. I think that, the fact that in the board's decision itself did not explain why it was making the decisions it did seemed to lead to some indications to us of bias, and so those were really why we laid those out.
I guess I would certainly prefer that it be, make more sense to me that if those were detailed as a part of your suggested findings of fact or whatever, rather than just making a blanket statement, certain members of the board are biased, wondering, who are you talking about? And what those statements were.
Okay.
That I would hope in the future you list those.
I will take that.
The only way we can change behavior is if you're clear on it, and we can consider it.
I will take that into consideration. Thank you.
Other? Did you had that pensive look on your face, Mr. Grover?
Were you, in terms of your question to the city now, was that in reference to the pleading or the?
No, it's their statement, the appellate issue statement of issues.
It's issue number one in the...
Their response.
Yeah.
No, in the appeal.
In the appeal.
The
Oh, in
appeal
their
that was
appeal.
filed on February 8th, 2016.
And given that there are no other comments, there are no other examples of what's being talked about, or who the board members were, or what was said, I wondered why that's out there.
My question was whether it was in the
it's not
court
really-
filing or in the board filing that Ms. Levy submitted. So, okay.
The bottom line is the board's being asked to give some clarification,
That is correct.
if it exists.
If it exists.
From the judge. Yes. Now, it is my understanding we may have a neutral member in the near future, and we will be back to 5 members of the board. One option would be to defer this decision.
So the judge did give us a collective of 60 days to respond,
Right.
so we would have to request an extension
And when would the 60 days end?
in about 2 weeks.
Yeah, his decision, I believe, was November 29th.
Yeah.
And we said 60 days from November 29th.
Well, it's interesting because think the reality would be that if that response would be written, unless Mr. Holland changes his mind the way he originally voted, I think I might end up having to write that response. Now, I'm not real comfortable doing that because I'm not the neutral member of the board. And I didn't write the original decision. Lee Pfeiffer did. So I'm just expressing some concern on my part. Would getting an extension be difficult to do, Mr. Heitman?
I'd be more than happy to draft that up for you guys, whether the judge permits it.
I thought you had an insight.
So, Judge Campbell is his own man and a good jurist.
And that's something we can discuss. Anything else? Either one of you can.
Nothing further from the city.
Okay, thank you.
Nothing
Thank you.
for Mr. Deere. Let that come back to me. Which is that he wants them to further detail aspects of their decision, I guess, so that he has clarity as to why they made the decision what they did. Now, the irony of it is that in their decision, they identified that there was the absence of this order that Mr. Deere allegedly was subject to, which is a no-brainer because there was no order. They never presented, here's the order that Jermey was given where he had to do X, Y, and Z. There was testimony by a lieutenant that told a deputy chief who since left the department that there was an order, but he didn't know about it. The supervisor didn't know about it. So the board has to identify something that doesn't exist in some further detail. Maybe that's just a matter of going to the record, going to the transcript, and providing further references like an attorney would if they're making a pleading to support a transcript here shows that there's nothing here. And oh, by the way, the record was absent of any documentation that shows he was subject to order, that there was ever any monitoring of any order, that the order was subject to any oversight, that there was any standard by which such an order can be considered lawful, any procedure for the management of an order, and it can go on ad nauseum. So they have a little bit of a task. Now, the thing that I'm, as a litigator, most concerned about is that we do have a board that consists of different people that weren't involved in that decision. So we have one person on it now that wasn't there during the case and hasn't reviewed it. It's a pretty sizable case, and then apparently another one coming in. I think they should be brought up to speed, or maybe it's just left to the remaining 3 people that were involved, and that would obviously be Mr. Hall, Mr. Reed, Ms. Moore, and so, they have a little bit of work cut out for them to make sure they comply with the judge's order. But
You said you don't want a rehearing.
we do not want a rehearing. No, players have changed. In some ways, actually, it'd be advantageous because we can confront Chief Eaton being the liar that he is. Absolutely perjured himself in testimony in that hearing and subsequent to this hearing. So, in some ways, it'd be favorable. But to us, this issue is dead. It's been resolved. There was no order. The basis for his termination was completely fabricated. They built it upon a IA investigation that they didn't want to produce, and now having been ordered to produce it, confirms what we thought. There was no order. It didn't exist. We have Chief Eaton in a sworn deposition confirming he never even looked at the IA investigation. He was sworn under oath, taken a deposition by Shannon Kennedy, and he lied about it. That's the landscape that we're in. So no, we don't want a rehearing. We want Mr. Deere put back on the streets as an officer of the Albuquerque Police Department. He was wrongfully terminated. We want his back pay and his seniority restored to where he was.
Does Mr. Deere have an expectation that he would actually be placed back on the streets, or that he'd be sitting in front of a computer?
There's a variety of things. There's obviously plenty of opportunities in the department, and I think that's something to be worked out with Mr. Deere. The reality is, and as the former DA's letter has shown, we're in a very curious bubble of its own little plane of existence here in Albuquerque. So whether it's the best place for Mr. Deere being in uniform patrol, I don't know. That's something to talk about. But the first thing is to get him reinstated and then address some of those details. Certainly when you're an officer and you're subject to a lot of litigation that's going on, I mean, as counsel for him, I would want to put him in a position where he's not exposed to any more litigation or put him in a position where he's constantly having to defend himself. So, you know, in APD, we all know there's dozens of specialized units where he could go. That being said, you know, it's not like the department has a standing policy that because you're subject to litigation, you're removed from, you know, positions of interacting with citizens. As we know, there's officers and supervisors that have multiple shootings that are still out there in uniform positions. So, you know, we just want what's fair. That's what it comes down to.
In terms of timeline, it seems like it's going to be a while. It sounded like they would like to explore the idea of getting an extension
Right.
until they get another appointed member, and then they have to figure out what they want to do there. What does this look like?
I wouldn't be surprised if the judge grants them like a 30 or 45 days extension. I don't think that's unreasonable given the situation that they've got to address in terms of the new composition of that personnel board. I mean, that's a fair thing to do.
If they ask for a new hearing, then would you fight that?
We'll oppose it. We'll oppose it, and it's outside the judge's order. The judge's order wants them to re-identify or reconfirm things that they use in support of their decision. So we'll oppose it.
So it sounds like you feel like the three existing members, the three members who were there when the board issued its first decision, could probably take care of this themselves and answer the judge's question.
I think that's accurate. I think, you know, the decision that this board made, that they provided, is fairly in-depth and comprehensive as opposed to other decisions that I've seen them make and how they're ratifying. And remember, that's the typical course of action that these boards make, is they ratify the city's action. You know, here we did fight it. We fought it very hard, and I fought it at a level that they haven't seen in terms of its depth of examination and scrutiny, which is what this matter resolved. I was not going to permit this officer to get run over the bus by this chief for the circumstances that he was alleging, which are purely fabricated. That behavior needs to come to an end. I mean, there's a bigger issue here than just this matter involving Officer Deere. It's all the other officers that are out there. This needs to stop. Using officers as political scapegoats for bigger issues and their own failures. It has to come to an end. And this is the first time where it's like, yeah, you know, this is where we can really challenge it and put it more into an objective and fair and reasonable playing field as opposed to a personality contest. So.
Good Sam.
Can I still for 2 seconds?
Yeah.
Let's take a check.
Yeah. Give me 1 minute. Yeah, something else for you guys.
Sorry about that.
All right. This is a copy of CPC filed in Gordon Eden for truthfulness and lying in court setting. Okay, this was filed today. All right, we've asked Director Harness to do a full-blown investigation upon Eden's testimony, both to the media in general regarding his statements to the media following the shooting of Mary Hawks, and then his statements during a deposition this past June as taken by Shannon Kennedy, and it's further detailed in this complaint.
Because in that deposition, he said he hadn't heard
He had reviewed I-9914, never seen it, never heard anything about it.
And you obtained a document with his signature on it.
That's correct.
Through the, it wasn't an IPRA complaint, it was a writ of
Mandamus.
Okay,
Yeah.
so what is that?
That document did not come from, that document that I guess the Free Press showed. My office has a copy of that document. That document was produced by the city in another matter.
Okay.
But as it shows, Eden purely reviewed it. Now, Mr. Deere had to pursue a petition for writ of mandamus under the IPRA statute to obtain portions of I-9914. The city has yet to finish supplementing its production with that material, but they will be.
Have they paid the $12,000?
We're still finalizing details in the order, but hey, each day goes on and fees continue to accrue.
Okay.
But that's. I think we're almost at the point where we've finalized an agreement on a stipulated order. We're ready to go.
But you filed this today with
Today.
Okay.
That was filed with the Citizen Police Oversight Agency today.
Okay.
And pretty much speaks for itself in terms of Eden's action. And I can tell you right now, having represented officers in IA, officers have been hammered for significantly less shading of the truth than what this chief did. And as the chief, you know what? Tell the truth, period. I don't care if it's disfavorable to you or the department, whatever, you own it, and you do tell the truth. And what he did is unconscionable. We're not going to let him get away